to our webinar on artificial intelligence and intellectual property issues and strategies relevant to artificial intelligence. I'm Anna Lloyd. I'm an attorney at Oblon, and I'm the moderator for the discussion. Sorry about that. This is a quick introduction to today's speakers. As I said, I'm Anna. I get top billing as the moderator. Speaking with me today are Samir Gokhale. He's my partner in the electrical patent prosecution group here at Oblon. He is very knowledgeable in the area of artificial intelligence. He's been working in this area for quite a while. And as well, we have Dr. Brendan Roach. He is an experienced patent agent with our firm. And again, he has a wealth of knowledge and experience in artificial intelligence, and he's been thinking and working in this area extensively. So to kick things off, Samir, artificial intelligence can be a little bit of a buzzword nowadays. What definition do you use when you speak about artificial intelligence in the context of inventions and innovations?
Yes, thank you, Anna, and good morning to Anna and Brendan. I know that we have a global audience watching our webinar, so I would say good afternoon and good evening to anyone who's on a different time zone than we are right now. I remember 5 years ago, I would give presentations on artificial intelligence, and I'd spend many slides trying to explain what is meant by artificial intelligence, because there was a mainstream understanding of what AI might be, and then maybe confused with some of the more modern advancements in AI that would be important to industry. Today, we won't spend too much time describing the background on AI, but I do believe it is important to define artificial intelligence to some extent, because different agencies all over the world are currently deciding to make laws and policies that are specifically directed to AI. For example, the USPTO had requested feedback from stakeholders who work in the field of AI. And one of the questions they asked the community was, what are the elements that go into an AI invention? So if USPTO and US Patent Office is asking that question in 2019, then it's, the term AI is clearly going to remain ambiguous for a while, which it could be interpreted differently based on the context. But the way that I usually like to define AI is shown on slide 3 right now. Generally, it's the intelligence that's demonstrated by machines, which may be contrasted with the intelligence displayed by humans and other animals. When you're working on AI patents, you start to see different characteristics that go into an AI innovation. Some of those could be a monitoring or sensing function, maybe by a camera, a microphone, or other device. There could be a learning aspect to it, and part of that learning is performed by object or pattern recognition in the data that's collected, possibly by that sensing function. And then to take it a step further, the AI invention starts to make decisions based on those patterns when it receives new inputs. And then finally, the AI can take action. In some cases, it doesn't take action. Maybe it's trying to learn more about the data, but in a lot of innovations, especially something like automated driving, there has to be a decision made based on the data that's being sensed. So these are the kind of characteristics that I see in an AI invention or innovation.
Okay, great. So can you give us some examples of artificial intelligence that we see in existing products?
Yeah, I think AI, it can be very explicit sometimes. It could be, a computer playing chess, or it could be a self-driving car, but it can be subtle as well. It could be the recommendations that appear when you watch a movie on Netflix or when you're shopping on Amazon. Sometimes AI can just be a simulation of AI. Like you might be playing a video game and you think you're playing against an AI, but it's really just a sort of brute force programmed object on the screen that is just reacting in a very strict way. Slide 4 I found some time ago. And I liked it because it shows kind of the different layers of AI that we see in industry. Kind of the outer layer is sort of general AI, and that includes some forms of simulated AI, like we might see in a video game. Maybe if you're using Microsoft Word a decade ago, you might see a little paperclip pop up and tell you, do you want to spell the word that way? Are you sure you want to do that? And it's designed to make you feel like you're talking to an AI, but it might just be very clever computer programming at hand. We go another layer inward, and it shows machine learning. And machine learning can come in different forms. Probably the most famous one is the IBM Watson device that you may have seen play the game show Jeopardy a long time ago. It is a more intelligent form of AI in the sense that it can actually correct its mistakes, through some kind of supervision. But it was attempting to correct itself as it went along, so it got smarter over time. And then we have deep learning, which I think Brendan is going to talk more about in a minute. This is sort of a very, very intelligent form of AI that can learn on its own almost if you just feed it enough data. You feed it maybe some labeled training samples, and it can start to recognize patterns on its own. And it doesn't have to necessarily correct itself; just need to keep feeding it data on what maybe a correct attribute is, so it can learn about it over time. It pretty much works the same way human brain works. And we're starting to see a lot of developments in that area, especially with image recognition technology today. So, AI comes in different categories and different forms, but I think, they all have some form of sort of intelligent processing to it. Some of them can learn, some of them can't learn, but they're designed to sort of simulate a human interaction or a human judgment in some form, I think.
Okay, so as Samir said, it sounds like machine learning has made huge strides lately. Brendan, what is machine learning?
Yeah, thanks, Anna. Let's see, next slide. Yeah, so machine learning, and it's really based on this desire as humans to have machines solve problems in the same way that we do. Humans, we evaluate new unknown things, and we look at past experiences, and we answer those questions, and we find logical answers, and we learn. We develop an understanding of something with two wheels on the front and the back, and handlebar and seats and spokes is a bicycle. We're not going to confuse that with a motorcycle very often. Now, that's it doesn't matter what size, shape, brand necessarily the bicycle is, it's still a bicycle. That's a simplistic example, and as we look at the way that machine learning is used today, it's really used to tackle problems that seem like almost insurmountable. They require large amounts of data. They're solving very complex problems, and so that's really where machine learning flourishes. And fundamentally, machine learning uses statistical models. It takes models that can use large training data set and reference data, for instance, and after training the model, it can be used to receive an unknown input and generate a prediction with some kind of probability of what that classification might be. When we get a little bit further into training, we talk about different types of machine learning being supervised machine learning, unsupervised machine learning, and semi-supervised machine learning. You have supervised machine learning is kind of the most intuitive in that you, as Samir was saying, you provide samples to a machine learning model that have been labeled by a human or by a computer, but they have true labels. And so when the training is conducted, it can really look at what it predicts is the correct answer and compare it with what it knows is the correct answer, and then back calculate through the network in order to improve it. And so it begins to learn, and bigger data sets obviously will improve its ability to classify these images. Unsupervised it's almost more interesting, but it's a lot more giving information that's not labeled to a machine learning model, and then it looks for relationships on its own, which is very cool. But underpinning all of this is really that we're using these machine learning models, we're teaching them, and then we want them to be able to take in an unknown anything and give us a prediction that we can use. So with that said, I'll just briefly talk about this image in case people are wondering what a machine learning model can look like. This neural network example is a very common example where you have an input layer. So your input images, data, whatever it might be, would go into this layer, and then it'd be processed by a number of hidden layers that separate the input layer from an output layer. And not getting into the weeds of what's in those layers, you can modify the number of layers you have, the number of neurons in each layer. You can modify the activation functions. You can change a number of things based on the experience that you need. And I guess that's to say, it takes a lot of human expertise to design these things as well. But again, the idea is to be able to provide some unknown something to the input layer and get a reliable prediction at the output layer.
Okay. All right, that makes sense. So how is machine learning used in modern industry?
Sure. So the most common, I guess, the most tangible example of this would really fall with autonomous vehicles. We know that companies like Tesla and others are looking to implement self-driving vehicles as normal. But in order to be able to do that, they need to be able to process large amounts of data. They need to be able to generate basically a 3D map of what's around the vehicle to know what it's encountering, and then determine, identify it, and then be able to respond to it and react. And maybe that is, an instance of stopping at a stop sign or avoiding an obstacle. Now, if you think in the olden days, you might do this by programming a system, hardwiring it almost to anticipate every single possible iteration of what a stop sign looks like, what an environment around the stop sign looks like. And it takes just a lot of muscle, and it's impractical, certainly, if not just impossible to do. And so if you think about how a driver would be able to, a human driver would be able to respond in these instances, maybe sometime we have lapses after longer rides in the car, but usually we can recognize a stop sign when we see a stop sign. And so that's what we want to be able to try to do, is to train a neural network to say, okay, I don't need all of the data in the world to be able to accurately classify the stop sign as a stop sign, or these solid double yellow lines as solid double yellow lines. I can do that with a small amount of data, and I can train a neural network on a smaller subset of data to be able to predict, okay, I've never seen the stop sign before, but I know it's a stop sign, and I know that, and we programmed it to say, when you see a stop sign, you need to stop. And that's really kind of a tangible embodiment of what we're talking about.
Okay, all right, so we've gone over the basics of artificial intelligence. Before we move on, I just wanted to make a note to our audience to feel free to submit questions through the questions tool, and we will address them at the end of the presentation, whatever we receive through that tool. Moving on, Samir, what are the intellectual property issues that affect artificial intelligence?
Yes, thank you. And one thing that's interesting about artificial intelligence is we discuss IP issues as a matter of law, in a way that's sort of different than if you had a new technology like a mobile phone or a new engine in a car, because there is something a little bit abstract about AI. As a technical field, it sort of lies in maybe a Venn diagram of being, a useful technological tool, like a self-driving car, like we mentioned, or just being an advanced form of data analytics. But whatever AI is to you as a company or a stakeholder is valuable, it is marketable, and requires a real amount of investment. So we have to constantly explore the boundaries of legal protection available in this field. Slide 7 shows sort of a menu of issues that we usually encounter when dealing with AI, and we will deal with these in some form as we talk today. One of those issues is subject matter eligibility. Another issue is the importance of the written description requirement, both in the US and also around the world. There's some issues related to whether or not you want to get patents versus trade secret protection. There are some issues with the licensing of AI, especially for a company that's leveraging AI as opposed to one who's sort of creating the neural network that Brendan described. There are some copyright issues as well, as AI is being used more in the creative realm as opposed to sort of practical realm. And finally, there's some important issues of inventorship which have come up over the years and have been partially resolved recently. So definitely want to discuss those as well.
Okay. So you and I, Samir, handle a lot of patent prosecution in US cases. And so we do deal with subject matter eligibility quite a bit. So what is special about handling subject matter eligibility in cases in patent applications that deal with artificial intelligence?
Yes, you know, I think I sometimes assume that the audience is familiar with sort of the famous case of Alice versus CLS Bank, but in case you're not, as a brief summary, 35 U.S.C. 101 is the U.S. statute that indicates what is patentable subject matter under U.S. law. In the Alice versus CLS case, there was a technique that was patented that was related to how two parties perform a financial transaction that reduced the risk of one side maybe failing to perform when it came time to settlement. This became a patent, and it was argued, throughout the court system that, this kind of patent should not be patent eligible because it covered sort of a basic business or financial concept. And the Supreme Court ultimately agreed. And kind of the broad takeaway from Alice that was quoted at the time was that, patent claims that simply recite an abstract idea are not patent eligible. And it applied to the facts of the case at that time, but it became a big deal in many cases under US prosecution because the holding was so vague that it could be applied to many different kinds of software patents, basically anything where maybe structure is not the innovation, to put it bluntly. But with AI cases, we have certain characteristics of AI that make it particularly susceptible to a rejection under 101 as being an abstract idea. One is that a lot of AI inventions are performed in software. Because they're very heavy in the algorithms they use, there's a lot of mathematical concepts, which also triggers rejection as an abstract idea in many cases. A third challenge is that many of the features of AI are related to data collection. As Brendan described, you take large sets of data to sort of feed AI to get your ultimate results. So, with that kind of data collection and analysis, there's some murky case law that has made AI cases vulnerable to rejection under 101. And the fourth challenge is that, a true AI invention, if it's realized, can sometimes come off as a machine that is literally replicating human activity. I mean, if you think about kind of the mainstream view of AI, it's sort of like it's something that's passing as human, in terms of human intelligence and human judgment. And sometimes it can get confusing in certain cases where functions that are previously performed by humans are being sort of swept under this abstract idea concept. So those are the four challenges that sort of highlight the particular issues that face AI inventions under subject matter eligibility issues, especially in the US.
Okay. So what does the case law look like regarding subject matter eligibility since Alice was decided?
Yeah, there was the problem with the Alice case is it came from the Supreme Court, but then the lower venues, such as the Federal Circuit, had to deal with the many cases after it. And we saw a lot of cases where things that may have seemed like inventive subject matter were being invalidated under the ruling of Alice. And there's many cases that invalidate claims under 101 after Alice. So as practitioners, we try to find some cases sort of tell us, okay, what will allow you to become something that's patent eligible under 101? And one of those cases that kind of jumped out right away was this case of McRow-Bandai, which is on slide 9. This particular case was directed to a invention where a human would program sort of an avatar shown on the screen to move its lips in conjunction with the audio that's being outputted at the same time. And conventionally, a human have to do the programming to cause this visual effect to happen. But the invention at issue in McRow-Bandai was basically allowing the system to automatically do this so the user wouldn't have to manually perform that function. Ultimately, the Federal Circuit found that this type of invention was patent eligible, meaning it was not directed to an abstract idea. What kind of important quote I usually pull from this case is that they describe that the claim uses limited rules in a process specifically designed to achieve an improved technological result in conventional industry practice. Now, the reason why this is important for AI, it wasn't necessarily described as an AI invention at the time when it was going through the court system, but you look at the facts of the case, what it involved was, previously lip synchronization and facial expression animation could be done by human animators using subjective determinations. But then with this invention, if you looked at it as being an AI device that's automatically performing that function, it was different than the human process due to the rules and conditions which trigger sort of that human-like determination or action by the computer. So the court really liked the fact that this was using set rules to allow the computer to perform its function sort of differently than a human does it.
Okay. So it sounds like McCrow really introduced the notion that incorporating rules into a claim is significant for patent eligibility. Can you clarify what that might look like?
Sure. I think one thing that I really like that the USPTO does that other agencies do as well is that they help teach their examiners about the nuances of case law by using example claims. And since we're ultimately seeking protection through the claims, I think it's helpful to show how some of these marginal issues can be compared in two different claims whenever possible. Now, my hypothetical claims probably lack in detail, but that's to make the presentation a little simpler right now. But on slide 11, I have a kind of two hypothetical claims that we're going to look at in view of McCrow v. Bandai. On the left side, you have the same invention. It's a method of recognizing an object in an image. The left side claim says determine the object based on its color and size. The right side claim says determine the object based on an angle of separation between its top face and bottom face being greater than a predetermined threshold. Now, the reason why I made these claims like this is because the claim on the left, although it's referring to the specifications technique in a very broad way, which is not done by a human, it still may broadly correspond to the human criteria for making a determination. So if your computer sort of automated device is doing things the same way a human would do, you might not have the right rules that sort of get you to where the facts of McCrow v. Bandai were. But on the right side claim, you've given some parameters. You have the angle of separation, you have this predetermined threshold between the top and the bottom face. These are kind of the special things that maybe image recognition on a computer will be looking for, but in our natural minds, we don't notice these things. We just kind of naturally, know, like Brendan said, something is a bicycle versus a motorcycle, but the computer has different rules that it operates by. And if you can get those rules in the claims, it gives you a much stronger chance of surviving subject matter scrutiny if you can kind of map this to the facts of McCrow v. Bandai.
Okay, so if McCrow is helpful, what's an example of a little bit of a problematic case when trying to obtain an AI patent?
Okay, on the next slide, we talk about this case a lot, Electric Power Group versus Alstom. The actual invention in this case was a method of detecting events on a power grid and displaying the events and analysis of the results of the events in a special way on the user interface. If you actually look at this case in your spare time, the claim is extremely long and detailed, and at first glance, the claim might come off as an improved method of detecting and analyzing events on an electric power grid. I think that's the way the inventors probably intended the invention to be interpreted as well. However, the case was found to be patent ineligible under 35 USC 101, and the quote that I put on slide 12 sort of illustrates what the court's takeaway was after they looked at these claims. They said, the advancement in this case purports to make a process of gathering and analyzing information of a specified content and then displaying the results, and not any particularly sort of inventive technology is used for performing those functions. One thing about this case is that it's been used a lot by the courts and a lot by patent examiners to reject a variety of claims during patent prosecution. I think, we've all seen this case come up, and even if the context of the claim may be something like, sending data from a mobile phone to a base station in the communications infrastructure, some examiners may look at maybe a narrow portion of the claim, see that data is being collected, data is being analyzed in some kind of way, the results are being displayed to the user. If that appears in the claim, they've kind of interpreted Alice to say, well, it includes an abstract idea, therefore I have to reject it as an abstract idea. And I think that this case has been very frustrating for that reason, because it kind of took a lot of things that involved data collection and analysis and kind of threw it under the bus of the Alice decision, essentially. And this is definitely a case that has created headaches in a lot of forms of technology, but with AI, as Brendan mentioned, AI, one of the key ingredients to AI is data collection. You have to collect a lot of data from many different sensors, sometimes all over the network. You have to feed it into the system, and you have to analyze it. And sometimes you perform an action based on that. Sometimes you just display something. But AI is very much tied into data analytics, and so this case has been very problematic for a lot of cases, but it's going to be problematic for AI cases as well.
Okay. So the data collection innovations, what do they look like in the field of artificial intelligence?
Yeah, so I think Brendan will get more into kind of what the black box of AI kind of looks like, but data collection is definitely a major input into those systems. I think one kind of innovation jumped out to me a while ago is the Google CAPTCHA feature. And if you went onto the U.S. Patent and Trademark Office website to initially access their public pair system, you were shown the Google CAPTCHA sort of test where they give you a bunch of images of objects. They say, select all the images with statues, select all the images with road signs, select all the images that have a bridge or a truck. And at some point you start to think, why do they keep asking about stuff on the road? Like, why is it that stuff I encounter when driving is what they keep asking about? And there's a method to this madness. They're actually trying to get the users to label images of stuff on the road, because those kind of images are pretty useful, for training stuff like autonomous driving and other kind of AI type tools. But to collect, the millions of samples you need to get a truly accurate AI, to do that, in an office somewhere or with manual labor, that can be very time consuming. So a lot of innovations use crowdsourcing, and this is one of them. It's sort of an innovative way to cause data to be labeled by a large number of people with less work. Some other areas of data collection, sometimes we talk about in the area of factory automation. You think about like robotics, working in a factory, sort of machining a tool, and they sometimes have a feedback loop where they sense data collection as a tool for the machine learning to sort of improve the operation of the tool. You can imagine maybe a robot is sort of manufacturing an object on an assembly line. You have cameras pointing at what it's doing, and when defects start to occur, that feedback can be given to the system. You can adjust the parameters on the device, and then it can improve over time. That's a form of AI because you're learning. The machine itself is learning. So that's a form of data collection, taken out of context, might get thrown under the bus under electric power. Another example of this, kind of taking a step even farther out, still in factory automation. This diagram I sometimes show that in the same environment, you could be taking data from these same kind of devices, these automated robotic arms, and you're not really using it in the feedback loop directly to adjust the parameters of the device itself, but you may be using it for some other purpose that improves operation of maybe the environment. Maybe you're collecting power parameters of the devices. You want to detect when devices need maintenance by the amount of hours they've been on, different things like that. And many environments are using these to sort of automate managing many of the tools they use, especially in industrial environments. So this shows a different form of data collection, similar field, but sort of different purpose. And you can see why this might get more scrutiny under 101 than the previous example, where you're actually altering the parameters of the machine itself to improve that device. This is sort of dangerously close to the example of electric power. You're maybe displaying the results to someone else, and then they have to take action. But these are 3 examples where data collection, we see it in AI, in different types of inventions, different types of environments, and why it's vulnerable to subject matter eligibility rejections.
All right, so the case law, it seems, can be complicated. How is the USPTO helping us? What guidance are they providing on this issue?
So, the USPTO has been sort of sensitive to the concerns of the stakeholders over the years. I think a lot of feedback was given to the PTO about the number of 101 rejections being given on a variety of cases that probably didn't deserve it, and they have been giving guidance over time to allow the examiners to make better decisions on what to reject under 101, so that we don't have this big backlog at the PTO of cases getting rejected under 101, or just kind of discouraging people from applying in general. And the key thing to remember about the U.S. Patent Office and other patent offices, a lot of people work there aren't lawyers. They sometimes have an engineering degree, and they don't want to study case law and kind of take a nuanced look at what was being held. So if you give good guidance, they can kind of go and efficiently perform their examination. One thing in the 2019 version of the USPTO's guidance is they created sort of simple tests to look at. And if you found that the claim was in the area of a judicial exception of subject matter eligibility, they wanted examiners to first check in a first prong, is it a mathematical concept, a mental process, or a certain method of organizing human activity? If it fell into one of those categories, then they could go to the next step. If not, they were not supposed to reject the case on a 101. If they found it fell in those categories, then there was another step they had to take. They had to look whether or not it's integrated into a practical application. And then, the USPTO gave some examples, which I think are always good to do. I think one interesting outcome of the examples that the PTO explicitly put out to the examiners in 2019 is they had this one example. It's called Example 39. It was literally directed to a form of training a neural network. So they're directly addressing AI in this example. And the example they gave was pretty simple. It was collecting images, modifying images to create a training set, feeding the training set to a neural network, making corrections to the training set, and then running them again through the neural network. And I'm not kidding when I say the claim was about as broad as I just described. But the PTO explicitly said this is not to be rejected under 101. And they were trying to make a point that they don't believe that this claim really fell into one of the categories of a mathematical concept, a mental process, or a method of organizing human activity. And I think this did send a message to the examiners that, there are categories of invention that we can find to be eligible without having to worry about all the details of the claims. And I think that they're trying to make clear that a method of training a neural network should be safe under 101. And so we'll have to see how it plays out over time. But I think they're definitely sending a message that they're trying to make it better to get claims in this area.
Okay, so we've talked a little bit about how AI is treated in the US. How is artificial intelligence treated in other countries?
Yeah, on slide 17, I think around the same time that the US was giving guidelines on AI, the EPO, sorry, I think I went too far there. The EPO is also giving guidelines on, sorry about this. This is I will not touch my keyboard yet. On slide 17, kind of summarize the guidelines that the EPO is also giving to their examiners for looking at artificial intelligence. One thing interesting about the EPO guidelines is it sort of seem to explicitly describe neural networks as falling into the class of mathematical methods. But this is something that PTO is sort of explicitly trying to say it wasn't in example 39 of their guidelines to the examiners. And so kind of just in a vacuum, I think the EPO is sort of saying like, yeah, without anything else, a neural network could be considered a mathematical method. But they gave some safe harbors that if it's serving a technical purpose, such as maybe generating a training set, contributing to some other technical solution, then it sort of created these safe harbors where you could still get something patentable. I think that they were kind of walking the line here between describing a neural network as something that was just a mathematical method, whereas an overall AI solution, could be considered patent eligible under EPO guidelines. So other agencies as well have sort of dealt with this in a similar way, sort of making safe harbors for AI type inventions, just to make it clear that it's not, going to be given the same level of scrutiny maybe some other types of inventions are, maybe like business methods or financial activity. So that's what we're seeing all over the world, sort of in harmony. A lot of the different agencies are sort of finding these safe harbors for AI and making that clear to examiners as well.
Okay, so the safe harbors sound to me similar to the practical application requirement in the US. So beyond subject matter eligibility, are there any other legal hurdles for AI innovations for patentability?
Yes. I think one other issue that is, something that we have to pay attention to is the idea of written description. In US law, sort of bluntly put, this is under statute 35 USC 112A, or formerly 112 first paragraph. But kind of the broad way of saying it is that your claims need to be supported and enabled by what's described in your specification. And I've shown a hypothetical claim on slide 18, as I like to do, as to how this creates an issue with AI. This claim is sort of in the area of autonomous driving, where you have a method implemented by a computer comprising capturing an image of a street sign on the road, outputting identification of a type of street sign based on the features included in the image. And the question arises, how many types of street signs need to be detectable to meet threshold under 112A? There have been some court cases in the past, sort of I put that in the small font there as to what the MPP says. But there's some court cases that said if your claim is really only, if your broad claim is only supported by one very narrow embodiment in your spec, and you don't have enough examples in your specification to support sort of broadly claiming the subject matter, then that creates an issue under 112A, and you have not either properly shown support or enabled your invention. In this example, maybe you're detecting stop signs like shown in Brendan's example, and you're specifically able to detect maybe the octagon shape of a sign, and that's what triggers the sign detection. In that case, you're not going to detect other types of signs like yield signs or exit signs or any kind of other non-octagon shaped slides. So you wouldn't be entitled to this product claim. So in this area, we've seen that this creates a tension in U.S. law because we're always trying to get the broad claim. We're always trying to get something that can be enforceable even against infringers that you might not know about at the time. It's very powerful in U.S. infringement cases to have these kind of broad claims, but with AI, where you're trying to do many types of object recognition, sometimes if you go too broad, you run into trouble.
Okay. So is written description an issue when attempting to patent something outside of the US?
Yes. Yeah, the Japanese patent office actually gave some pretty detailed examples. They had in their guidelines or guidance for examiners in 2019, they gave examples on the support requirement and the written description requirement. And I'm not going to go into all the details shown on the screen of the claim, but basically this claim is sort of directed to detecting features in facial images to detect what maybe the sugar contents of someone's vegetables might be in their diet. And it didn't really get specific enough for the Japanese patent office and how they do this in the specification. So they found that this description only discloses maybe a certain correlation between the face image of a person and the sugar content of a vegetable, but it's not for sort of all different kinds of facial features that this claim could possibly cover. So they're very concerned about this idea that with AI type solutions, you'd be performing object recognition, but you may be trying to cover something that you haven't actually realized how to do yet. And the idea of correlation is mentioned a lot in the GPO examples, but it's sort of similar to the concept in the US. But I think in the US, in my personal experience, the examiners probably don't give it as much scrutiny as maybe they do in other countries.
All right. Well, Brendan, I think it's time for us to switch gears a little bit. We've talked about the statutory issues. Let's talk about some practical issues. What are some considerations for companies seeking to get themselves a patent in the area of artificial intelligence?
Yeah, absolutely. You know, as someone who does a lot of drafting, I see a lot of different types of companies that want to get a patent on something that is innovative in their businesses. And what we tend to see as everyone starts to implement some kind of AI in their inventions is that they tend to fall into two general categories. These are companies on one end that are really developing the technical expertise and the models that are behind the artificial intelligence. And then on the other side, we have, you know, companies that are more interested in using existing machine learning models or artificial intelligence systems to improve their customer service or their business in some kind of way. And so on that one side, where you have companies that are developing AI, you can think of a company like Amazon, who has an Alexa voice assistant that implements certain speech recognition systems and natural language processing and other types of systems that allow it to listen to you and respond in kind. There's NVIDIA that develops GPUs that really are what enable faster and faster processing of certain types of neural networks, and doing that in parallel and doing a lot of image recognition in particular. You know, they're at the forefront of that. And switching a little bit to look at someone like Salesforce that's developing their own AIs for their customer relationship management services, really trying to improve their APIs and their platform generally to improve the customer experience. So that's one bin of companies. The other bin of companies tends to be companies like Wayblazer. They've since ceased operations, but they along with RareCarrot both focused on using IBM Watson as the ground, as the foundation for doing AI, for providing it to their customers. So in one instance, they were looking to, you know, match users with certain types of travel, and in the other instance, they're matching users with jewelers who happen to have, you know, discounted diamonds. But that's kind of setting up these two different categories, and these companies have the same issues when approaching how to obtain a patent, and they also have different issues. And it really comes and it really helps you determine whether or not patent protection should be sought at all.
So if I'm a company that's operating inside the black box, what should I be thinking about?
Yeah, I set it up as this kind of theory of black box relativity, because there's really the companies that are developing the AI are kind of inside the black box, and the companies that are outside that are implementing these technologies are really just focused more on the outside. So we say inputs into this black box, some magic is done on the inputs, and then it outputs something that's useful. So I think it helps for companies when they are actually coming to talk about their inventions to really think about the differences between a company that develops AI and a company that doesn't develop AI. Because you'll have companies inside that are going to have to focus a little bit more on the technical aspects of their models. Do they have special architectures that span different devices or new ways of processing data? Whereas the companies on the outside have different issues that they need to focus on, and those things really drive what the invention looks like and helps their decision processing as they move forward. And what I mean by, you know, this is really, if I'm someone who is an inside the black box person, and from a drafting perspective, certainly it's important to think about what might actually be patentable in your process. Yeah, in certain cases, the structure of the model itself and the neural network, how many layers it has, you know, how many neurons it has. Is it something that's performed in parallel? Is it something that's distributed from a user device to the edge of the network, to the cloud of the network? You know, is there something unconventional about the structure of the model itself that's patentable? That's certainly something that you can focus on as an inventor. But it's also important not to forget that the model has to be trained, and a lot of times the training is done in certain ways that in and of itself is useful. You know, of course, there's certain things to consider, such as companies that train models are not always companies that implement the models. Certain companies will fabricate hardware that have that are trained to implement certain models like NVIDIA, but the people who actually use those models are different entities. And all of that is also to say that there can be questions, and we'll talk about this a little bit later probably, but questions of, if I'm trying to patent a training process, how can I actually determine if someone is doing that process? And so while there are a certain number of companies that are doing that inside the black box approach, a lot of what we tend to see, and this goes along with the data collection stuff that Samir was talking about, is most companies are really more of an inputs outputs approach kind of thing, where they're using more off-the-shelf machine learning models and artificial intelligence networks, but they are trying to do something different with, maybe they're doing something different with the way that the input data is cleaned, because all data needs to be cleaned. A lot of people who are developing these things probably don't even think about it, but the way that data is pre-processed is an important consideration. Possibly whatever comes out of your artificial model is unique in such a way that maybe it's not actually a finished product. Maybe it needs to be manipulated a little bit more in order to be used, and maybe there's some downstream instruction or control system that is used, and all of these types of things can be focused on the ends of the black box, because really the intent is not to capture what's inside the black box, because that's that's not what you're doing. Now, one thing that I think a lot of people fall into the trap of is thinking that, well, I have a large amount of data. I have the best data sources in the world. No one else has data sources like we do. I'm going to apply a typical model to my data, and I'm going to get better results than anyone else does. Well, that's a difficult approach, because you're not doing necessarily anything special to the data. You just have different data. So be careful when it comes to trying to obtain patent protection for simple combinations of large data and machine learning models, because they are simple and can be viewed that way, and it will be difficult. It might be difficult to obtain a patent going down that road.
Okay. So can you get a patent on a neural network or the black box that you described?
Yeah, you certainly can, and I think we have talked about this. It really comes down to, is your technique unique within your neural network? Are you improving the way that you're processing your data? Are you changing something about the network that allows it to be more robust? Are you adding something to the field? Is it faster? Is it more accurate? There's lots of things you can look at. Now, with those considerations, it's important to think about, is this something that I even want to obtain a patent on? Protecting the neural network itself is good, but a lot of companies want to invest a lot of resources in this, and there is a trade-off between disclosure and protection, and sometimes the best approach might be to look at what you're doing and maybe have a patent that is the core technology that you have, but maybe fill in around it with some kind of a trade secret approach, because you don't want to disclose everything, and if you can't tell someone that a competitor is doing what you claim, then that might become an issue for you.
Okay. So it sounds like there's a lot of companies that are trying to work on algorithms for artificial intelligence, maybe behind the scenes. Can you explain how these companies are trying to leverage these developments to bring artificial intelligence to the user?
Sure. Yeah, I think the black box idea, although maybe people don't like to say black box because there's a lot that goes on in black box, but if you think about it as being, in one instance, object recognition, the object recognition can be applied to a number of industries: autonomous driving, facial recognition, skin treatment. And while on the surface it might seem the same, these are all kind of inputs, outputs approaches where you are doing something fundamentally different. And for that reason, they might be patentable in different ways. And I think, just to talk about maybe a practical example of all of this, is to look at a washing machine. This is consumer electronics, of course. Everyone has a washing machine. And the idea being that if I'm a company and I'm developing a washing machine. Maybe my washing machine is connected to the internet. Maybe I have a microphone or some kind of sensor that can evaluate the performance of the motor. And when I say evaluate, I mean record some data about the motor and then transmit it to my company who has servers. Our servers have neural networks that have been trained on loads of data to identify when that motor might become faulty or not. And so what this sets up is a company that might be looking to patent this, and they have kind of two bits. You know, they have, on one end, they have a detection where they can the washing machine can transmit data to a server. The server can apply the neural network and say, ooh, I hear something in your motor that doesn't sound quite right. I think you might want to check something about it because it might be becoming faulty. And then on the other hand, you have all of these machines that work. Some of them work, some of them don't work, but you're still collecting all these data from these microphones. And it's important to remember that not only are you building something that can be implemented for the user experience, but you're also building an invention that can be seen from the other aspect as well. That can be seen from the side of, well, we're training a neural network that can better and better predict when this motor in this washing machine might be faulty.
Sorry, give me a moment. I'm having some technical difficulties.
And I can jump in if that's okay.
Sure. Go ahead.
Yeah, I think with Brendan's example on the screen, slide 28, we take this laundry appliance and how does that actually translate to claims? Because this is what we care about in our field. The claim on the left is sort of an all-inclusive claim. It has the motor, the microphone, the communication interface that connects directly to a server, and a display. And it performs all those features that Brendan described on the previous slide. The problem with this claim is that it's probably limiting because it has too many details. It has something like the display, actually may not cover what we call maybe a pure training scenario. I mean, you don't need to alert the user that their laundry machine motor is about to break down if you're only using the data for training purposes back to the home server. Also, the type of sensor might be too narrow. If you have a microphone, you have to think about different types of sensors that can maybe collect the same kind of factual events, maybe like a vibration detector or the like. Also, if you're transmitting your data back to a single external device, you might be ignoring the possibility of having multiple devices in the cloud. The claim on the right is sort of shown to sort of solve some of these problems. It takes out the use of a display, so now you can actually cover the display display scenario, but it's just not putting your claim, so you can still cover the pure training scenario as well. You're transmitting to a network, not just one device, so maybe you can cover a cloud sort of server-based system as receiving the data. And this might still face an obvious challenge, and as practitioners, you have to find the details that we do want to expand upon. Maybe instead of describing a microphone or a vibration detector, you're detecting an oscillation condition, and that's a detail that gets this patent allowed. So you want to work around those edges while covering as much as you can, while also trying to overcome the obviousness hurdle.
Okay. Well, we are getting close to the end of our time, and I want to make sure we've got some time to answer some questions. So, do we have any just tips for things to consider in the IP space for our audience?
Yeah. I think that we talk about enforcement, right? I'm going to go through this slide really quickly. We have AI sort of has a cloud Internet of Things type nature to it. So you don't want to target maybe one single device in the network, and you have to consider who the potential infringers are and make sure your claims cover a variety of claim scopes, such as maybe a mobile phone or IoT device, maybe the way they communicate with each other. You want to get different kinds of software level claims. But the bottom line is you have a system kind of solution. This creates sort of a joint infringement problem. So you want to consider claims very carefully in that scenario. We had some other slides to kind of go into some other trends that we see. There's a lot of the big industries that get patents are in transportation, telecommunications, and personal devices, as we talked about. And this is this graphic is provided by Whitebow that they released last year. But sometimes you have something in an up and coming area that we're trying to leverage AI that maybe is not as obvious to see the issues. And so one of those issues we took a closer look at was maybe business operations or document management and workflow. And this slide is just trying to show how AI is used in these areas, which may traditionally be not something you imagine AI being used for. But I think in today's day and age, with the pandemic and people not being able to have face-to-face interactions, you're going to see a lot more innovations in this area about how to use AI to read documents, scan documents, sort documents, and provide security on different forms. Maybe there's a major event coming up in 2 weeks where a lot of documents have to be analyzed and processed, and we're going to wish we had this kind of technology. In these kind of scenarios, again, the data collection issue comes up. You're going to want to recite specific elements of the system, such as the printer, the scanner, the remote communication. You want to emphasize the practical application as much as possible. And one of the challenges is you're using a lot of existing tools like printers, scanners, existing networks, and you're kind of combining together for this AI solution, and you're going to have an obvious issue with that. So you want to look at your system or process details that create sort of the unique context. Maybe you have certain timing triggers or certain remote access. Another tip that sort of gets lost in this, especially if you're a non-US company, is be careful the terminology you use if you're in one of these areas. You want to avoid the business method art unit at the USPTO. They have like a 90% rejection rate, and you will probably see a 101 rejection, and it can be very tough. And maybe you don't do a business method, maybe it's a legitimate technological tool, and you just happen to get in there. And we see this happen to our clients all the time, and it's just be careful the terms you use in your specification.
Okay, so you and Brendan mentioned some companies are leveraging AI developed by other companies. Does that create any licensing or royalty issues?
Yeah, and really briefly, kind of the issue you see with if you have one company making the AI, maybe the algorithm for building a neural network, and you have another company, maybe the car company or the cosmetics company, that is taking their own training data to make their own AI in their specific industry, is sort of equivalent to the video coding sort of licensing genre that you see today, where you're licensing the software to make sort of another marketable product. And an issue comes up, about whether or not you get the company that makes the algorithm can get downstream royalties for whatever the company that's actually selling to the user is making. The other question is, if you're just taking existing off-the-shelf software to build your neural network and you're using techniques that are known, feeding into labeled images, if you're trying to get a patent in this area, you got to really think about your contribution to avoid obvious issues in this area. So we see these issues pop up with kind of the dual company nature that Brendan brought up. I'm kind of working together, but one company is going to be making all the money. So that's sort of the blunt way to look at it.
Okay, so we've talked almost exclusively about patents. Are there any other forms of intellectual property that need consideration for artificial intelligence type issues?
Yeah, and just really briefly, AI is very smart. You can feed it copyrighted music, and it could come up with its own unique song. This is raising a lot of eyebrows right now. So, whether or not that constitutes copyright infringement, it does raise a lot of issues in this area, and there will probably have to be some licensing involved if you're going to try to make money using this technique. But it's something to keep an eye out as more companies trying to use this to create sort of creative works of art based on inputted images or other artwork.
Okay, so AI can be used to create music art, but I think the hot question right now is, can AI be an inventor?
Yeah, I think this came up a while ago as AI was getting more and more advanced. Can a machine actually make the inventive leap? And one example I used to use was AI uses pattern recognition. Sometimes solving a problem or identifying problems leads to the inventive step, and if the pattern sort of helps you identify the problem, how helpful was that in actually making the inventive concept? The USPTO, the EPO, and I think other agencies have sort of nipped this in the bud, and they've sort of announced their own conclusions that AI legally cannot be an inventor on a patent application. it must be a natural person. But there could be some other questions that arise in this issue as well.
Yep. Okay. So let's kind of bring it all together. To Brendan, actually, what are some of the practice tips that you've got for practitioners in this area or for business people?
Sure. Yeah, very briefly, given respect of time, you know, it really depends on what kind of company you are. You want to make sure that you're doing the right thing. You're focusing on the right areas of your inventions. As Samir said earlier, you want to make sure that you are addressing any one-on-one issues in advance. You want to make sure that whatever you want to claim, it is supported by whatever's in your specification. You don't want to claim something that's so broad if the only example you have is, you know, being able to spot a cow that has spots on it. If that's the only thing you can do, your fundamental technology has to be translatable. We also want to look at the applicant's contribution to the overall result, and also any unique processes that you're doing to create, I guess, a unique context, as we say here. And lastly, you know, I don't want to give the impression that patent protection and trade secret protection is essentially on equal footing. You know, there's advantages and disadvantages to both in this space, and in particular when it comes to AI, maybe you don't want to disclose something. Also, you don't have the same protections that you might have if you did go ahead with patenting something. There's certainly just things to think about.
Okay, well, great. Thanks for summarizing everything. We do have time for maybe just a few questions. Or one interesting one that comes up is that given the inventorship guidance that we've gotten from the USPTO and the EPO about, you know, what AI can't be an inventor. Okay, well, will that come up again in the sense that if an AI does contribute substantially to some sort of invention in the future, and of course can't be listed as an inventor, could that ensuing patent then be challenged on the grounds that inventorship is incorrect, or something along those lines? What do you guys think?
Well, my opinion is if the challenge is available, I think someone's going to use it. If the facts of the case kind of make it look like, you know, AI is being heavily relied upon to come up with the invention, I'm sure that we'll see a creative defense for infringement come up in the future that pinpoints that as an issue. So that's a very good question. Yeah.
Actually, we have a follow-up question on the same topic. The question is, given the DABUS patent application in Europe, does this potentially affect claim drafting in some way going forward?
Yeah, I think that's an interesting question. I think you probably don't want to be too explicit about how AI, you know, is used in the process of creating an invention. You want to kind of avoid a description where it's sort of the solution to your problem sort of automatically came by hitting a button on your computer. I think that's the best way. You want to emphasize your contribution. You want to emphasize how the problem was identified and how it was solved, and make sure that, you know, it was really sort of, you know, as we say in bluntly in patent law, you know, make it seem like the flash of genius actually happened. That it's hard to solve before, and you uniquely solved it. Yeah, that's kind of a quick answer.
Yeah, I would agree with that. I think you also may not even be able to get the patent on the claim if you don't provide that additional description, because then it appears that all you did was find some stuff to throw into a network, and out came something, and you were as surprised as anyone was that you got such a great result. Like you're going to have to do a little bit more to show that you've done something beyond what the neural network can do on its own.
Right. Yeah, that makes sense. Okay. Well, I think we've come to the end of our webinar. If any members of the audience want to engage with us afterwards, we're always happy to answer follow-up questions. We've got here a screenshot from the Oblon website. We have an artificial intelligence team of professionals who are available. We also have We often publish on this topic, so feel free to keep your eye out for upcoming articles. And Samir, I hear there's a blog coming.
Yeah, we're probably launching it either today or tomorrow. Where we have some blogs on our current website for the life sciences and design patents. I think an ITC blog as well. And we've decided that this is such an important topic that we have so much to write about that we're going to start a blog with regular contributions from everyone you see here on the panel, as well as the other fine professionals at our firm. So it's probably maybe by tomorrow that'll be live on our website.
Great. Well, I'm excited to participate in that. And I think, does anyone else have anything to add? Samir and Brendan?
Yeah, I encourage anyone, if you have specific questions, feel free to contact us, and we'll be glad to help you out. We know that this is a limited time, and there's a lot on this topic that we can't get to, unfortunately, but we definitely would like to help everyone out as much as possible.
Absolutely. Okay, well, thank you everyone for your time and attention, and that concludes your seminar. I hope everyone